Welcome to the Tejswi IP show. In this podcast, we dive into the world of intellectual property, like patents, copyright, trademark, geographical indication, design. We also analyze the recent events shaping the IP world. Today, we're embarking on an exploration of a field that's truly at the cutting edge of innovation and intellectual property. Computer Related Inventions, often abbreviated as CRIs.
That's right.
We're talking about everything, really, from the software powering our daily lives, the apps on your phone, to the complex algorithms behind the latest advancements in AI, blockchain, even quantum computing.
It's a huge area.
It really is. It's a space where technology is just moving at lightning speed. And the legal frameworks protecting intellectual property, well, they have to work incredibly hard just to keep pace.
They certainly do.
So our mission today is to unpack the intricacies of how these digital innovations can be protected and, crucially, what exactly makes them eligible for patent rights here in India.
That's right. And it's a fascinating area because as information technology continues its rapid transformation, you see advancements in AI, machine learning, blockchain, quantum computing. It becomes absolutely crucial to understand how these complex algorithms, these new data processing techniques, and sophisticated hardware-software integrations actually fit within established patent frameworks.
So it's about fitting the new tech into the existing rules, essentially.
Exactly. We're here to clarify the key distinctions, provide insights into how these innovations go beyond what you might think of as traditional software, and really offer tangible technical solutions. That's the key, the technical solution.
So what does this all mean for you, our listeners? Whether you're an inventor out there pushing the boundaries, maybe a tech enthusiast just curious about how innovation is safeguarded, or, just someone looking to understand the legal landscape of this digital world. We're going to break down the essential terms first.
Yeah, get the foundations right.
Then navigate the legal landscape, focusing on India, and then, importantly, look at practical examples. Real-world stuff that illustrates what makes a computer-related invention genuinely patentable.
Okay, let's get into it.
Defining the digital landscape, key terms and concepts.
All right, so before we dive into the real nitty-gritty of patentability and, the legal tests, let's establish a common vocabulary. The world of CRIs uses some pretty specific terms, and understanding them is, fundamental to grasping the whole subject.
Absolutely. Think of it like learning the rules of a game before you start playing, right? Clarity on these definitions helps us understand the precise boundaries. What can be patented, what can't. So first up, a concept that's really foundational. An algorithm.
Ah, algorithms. Yeah, we hear that term everywhere now. Social media feeds, self-driving cars, it's constant. But how does IP law actually define it? And why is that definition so critical for patents?
That's a great point. An algorithm is essentially a precise set of rules or instructions for solving a problem, usually laid out in a finite sequence of steps. You could think of it like a very detailed recipe or maybe a flow chart. Now, here's the critical distinction in patent law, and this trips people up sometimes. While the expression of an algorithm, so the specific way it's written down, the code itself that can be protected by copyright.
Okay, so copyright for the code.
Right. But the algorithm itself as an abstract intellectual exercise, just the sequence of steps, the logic, that's generally not eligible for patent protection. This was very clearly articulated by the Madras High Court, actually, in a case involving Microsoft technology licensing back in July 2024. They highlighted that simply devising an algorithm, because it's an intellectual exercise, is limited to copyright protection for its form of expression, assuming it meets originality criteria, of course.
So the underlying idea, the logical steps themselves, can't be patented. Just the specific code that expresses it can get copyright.
Exactly. It's a nuanced difference, but a very important one. The abstract idea versus the concrete expression.
That makes sense. Form versus function, kind of.
Yeah.
What's next on our list?
Next, we have computer. Our understanding of what a computer is, legally speaking, here in India, comes from the Information Technology Act 2000. And it's a very broad definition, actually. It describes any electronic, magnetic, optical, or other high-speed data processing device or system. Basically anything that performs logical, arithmetic, and memory functions by manipulating electronic, magnetic, or optical impulses.
So pretty much any modern processing device.
Pretty much. It really covers the whole ecosystem. It includes all the input-output processing, storage, the computer software itself, or communication facilities connected to it within a system or network. It's thinking about the whole integrated setup. And building right on that, you have computer network. This just refers to the interconnection of one or more computers.
How they talk to each other.
Precisely. Could be through satellite, microwave, terrestrial lines, whatever communication media. It also includes terminals or, a complex of two or more interconnected computers. And it doesn't matter if that connection is continuous or not. It really emphasizes that interconnected, often always-on nature of modern computing, how it functions like a single distributed system.
Okay, so we have the abstract steps, the algorithm, the physical machinery, the computer,
Yeah.
and how the machines connect the computer network. What about the actual programs that make them do things?
Exactly. That brings us to the computer program itself. Now, the Copyright Act of 1957 gives us a specific definition here. It says, a computer program is a set of instructions expressed in words, codes, schemes, or any other form, potentially including a machine-readable medium that can cause a computer to perform a particular task or achieve a specific result.
So this is different from an algorithm. How so?
It's distinct because it's the executable form of the instructions. If the algorithm is the recipe, the computer program is that recipe translated into instructions. A specific oven, or computer in this case, can actually follow to bake the cake. It's the thing that makes the computer do something. And of course, underpinning all this, we need to be really clear on the difference between software and hardware. Software, as we generally understand it, is the programs, the instructions, the data that control what a computer does. It's like the intangible brain.
Telling the physical parts what to do.
Exactly. While hardware encompasses the physical, electronic parts of the processor, memory chips, circuit boards, the screen, keyboard, the tangible body. This distinction is absolutely crucial in patent law because, as we'll get into, patentability often hinges on how that software interacts with the hardware to create a technical effect. It has to move beyond just being abstract instructions.
Okay, and that brings us to a phrase you mentioned earlier, a legal term that seems really important here. Per se. Sounds simple, but you said it carries a lot of weight for computer programs.
You're absolutely right. Per se. Latin, it means of, in, or by itself, standing alone, without reference to additional facts. Now, when we talk about computer program per se, it's critical. Why? Because it signals it's not a blanket ban on patenting software. That same Madras High Court case involving Microsoft clarified this too. Per se implies something considered alone, not with other connected things. So in the context of computer programs, it indicates that while a computer program as such, just the code on its own, might be excluded, an invention that includes a computer program but does something more.
Something more. Like what?
Like providing a significant technical effect or making a technical contribution. If it does that something more, it might very well be patentable. This nuance is absolutely key to understanding the Indian patent landscape for CRIs. It's often misunderstood. People think software just can't be patented, but that per se makes all the difference.
The legal framework for computer-related inventions in India.
Okay, now that we've got our terms straight, let's talk about the specific legal rules, the provisions governing CRIs in India. When we consider patenting any invention, really, we always have to start with the basic definition of an invention itself, don't we? What are those fundamental pillars an innovation has to satisfy?
Indeed. Under India's Patents Act, 1970, an invention is defined quite precisely. It means a new product or process that involves an inventive step and is capable of industrial application.
New product or process, inventive step, capable of industrial application. Three things.
Three essential pillars. An invention must meet all three. No exceptions.
Okay, so new product or process seems fairly straightforward. It hasn't existed before. Capable of industrial application, you can make it or use it in some industry. But what about inventive step? That sounds like it's more than just being new.
It absolutely is. An inventive step implies a feature of an invention that shows a technical advance compared to what already exists. Or it has economic significance, or maybe both. And here's the real kicker. It must not be obvious to a person skilled in the art.
A person skilled in the art? Who's that?
That's a hypothetical person who works in that specific technical field. They know the existing solutions, the common problems, the standard techniques. The invention needs to be more than just a routine improvement or a logical next step that this skilled person could have easily come up with based on what was already known. It requires a spark of ingenuity.
So it's a higher bar than just novelty.
Much higher. And that other part, capable of industrial application, just means the invention can actually be made or used in some industry. It signifies it's not just a theory. It must be workable, useful, have a practical application with a concrete benefit. You can't patent a perpetual motion machine concept, for example, because it's not workable. Mere speculation isn't enough. It needs real-world utility.
Okay, now here's where it gets really interesting and maybe a bit tricky for CRIs. The Patents Amendment Act back in 2002 introduced specific exclusions under Section 3K. This section basically lists things that cannot be patented, even if they meet the other criteria, and CRIs get a specific mention here. This is often where software inventors can hit a snag, right?
That's a critical point, yes. Understanding Section 3K is absolutely paramount for anyone trying to patent CRIs in India. It explicitly excludes four main categories, and these often cause confusion. First, a mathematical method is excluded, purely abstract mathematical approaches. A new formula, a method of calculation on its own. These are seen as intellectual exercise, discoveries perhaps, but not practical inventions in the patent sense.
Okay, pure math is out.
Second, a business method, strategies for commercial activities, administrative processes. And importantly, this exclusion is absolute in India.
Absolutely.
Meaning, if the core of your invention is simply a way of doing business, a new pricing strategy, a customer management technique, even if you implement it using fancy technology, it's not patentable. The focus is on the nature of the method, not just its implementation. This is a really significant difference compared to places like the US or Europe.
Got it. So no patents for just a clever business plan, even if it runs on software.
Correct. Third, an algorithm. As we discussed, an algorithm is that set of logical steps. If it's presented purely as an abstract concept, an intellectual exercise without a specific technical application or implementation, it falls under this exclusion. We need more than just the idea.
And the fourth one, the one you said is really key for software.
Yes, the fourth limb, and probably the most debated and nuanced, a computer program per se. This is the one that really defines the patent landscape for software-related inventions in India. And again, that term per se is absolutely crucial. It was deliberately included. The Joint Parliamentary Committee back in 2002 explicitly noted that the intention was not to reject inventions that are merely ancillary to or developed upon a computer program, provided they are true inventions and offer a technical contribution. The core idea is that computer programs as such, meaning just a string of code, a set of instructions without a demonstrated technical effect on hardware, or a solution to a technical problem beyond normal computer operation, those are not intended for patent grant.
Okay, so it's not a blanket ban on anything involving software. It's much more focused on what that software does in a technical sense, how it interacts with the real world or the machine itself.
Precisely. It's about the substance, not just the form. This naturally raises the big question. How have the courts in India actually interpreted this per se provision? What tests has they developed to help us figure out if a CRI is patentable or not? Because without that judicial guidance, it's just words on a page.
Exactly. We need to know how it works in practice.
And this is where recent court decisions, recent jurisprudence, become absolutely vital. They've shaped our understanding significantly. Indian courts have consistently articulated key interpretations, bringing much-needed clarity. One of the most fundamental interpretations, really a landmark ruling, comes from what we call the technical effect and technical contribution test. This was heavily emphasized in the Ferid Allani case back in December 2019. The Delhi High Court stated quite emphatically that if an invention demonstrates a technical effect or makes a technical contribution, it can be patentable, even if it's based on a computer program.
So that test is the gateway, essentially.
It's absolutely crucial. It fundamentally shifts the focus from the form of the invention, is its software, to its substance and its real-world impact. It means you can't just claim a program in the abstract. You have to show how it genuinely advances technology or solves a concrete technical problem. How does it make the computer or the system it controls work better in a technical way? It's about transforming a general-purpose computer into a specialized machine for a technical task.
That makes a lot of sense. It's not about the code itself, but what the code enables the machine or system to do technically.
Exactly. And building on that, another case, Microsoft Technology Licensing versus the Assistant Controller in May 2023, the Delhi High Court clarified this further. The court looked specifically at whether the technical solution went beyond just designing user interface, making things look nice or easy to click. Was it closer to the heart of computer and network technology?
Meaning?
Well, for instance, they found that using cookies and two-factor authentication for network-level communication protocols was patentable because of its technical aspects. The solution wasn't just about user convenience on screen. It was about enhancing the fundamental functioning of the computer network itself, improving security and efficiency at a deeper technical level.
Okay, so improving the core tech, not just the surface layer.
Precisely. Now, let's connect this back to business methods for a moment. The OpenTV Inc. case, also in May 2023, delivered a very clear message that really distinguishes Indian law. The Delhi High Court explicitly stated that in India, the exclusion for business methods under Section 3K is absolute.
Absolute again. No wiggle room.
No wiggle room. Unlike in the UK or Europe, that per se qualifier we talked about applies only to computer programs, not to business methods. This means if the core of your claim is fundamentally a business strategy or an administrative process, even if it's implemented with sophisticated technology, even if it produces some kind of technical effect as a byproduct, it will not be patentable in India. The court said the only question is, does the application address a business or administrative problem and provide a solution for that, rather than a technical problem?
That's a very clear line in the sand. No amount of clever tech implementation can save a pure business method claim here.
That's the bottom line. It's a critical divergence from other places and key for anyone drafting claims involving business processes in India.
Okay, what about mathematical methods? You said the mere presence of a formula isn't automatically fatal.
Right. That came up again in the Microsoft technology licensing case in Madras High Court in July 2024. They highlighted that just because a claim includes a mathematical formula doesn't automatically mean it falls under the mathematical method exclusion. The context is crucial. Is it part of a broader technical process? The court clarified that the exclusion targets the mere expression of an intellectual exercise, like a method of calculation itself. But it doesn't exclude inventions that use mathematical formulae if those formulae lead to practical systems for encoding data, reducing noise in a signal, encrypting communications. It's about the transformation from abstract math to a tangible technical solution.
Using math as a tool within a technical invention.
Exactly. And this leads to a really crucial point about hardware. For a long time, there was some uncertainty. Did your software invention need to involve new, novel hardware to be patentable? Well, in the Raytheon Company case in September 2023, the Delhi High Court explicitly stated that requiring novel hardware for CRI patentability lacks any basis in law.
Wow, that's quite definitive.
It was. It strongly reinforces that the technical contribution or effect test is what matters most, not whether you've invented entirely new physical components. Software-driven innovations don't need brand new machines to be patentable. They just need to make existing machines or systems perform better in a demonstrable technical way.
That must be a huge relief for many software developers. It really shifts the focus to what the software achieves technically rather than what new physical bits it uses.
Precisely. It acknowledges that innovation can happen purely through clever software controlling standard hardware. And further strengthening this idea of technical effect, another Microsoft technology licensing case in April 2024 stressed that an invention using computer programs must contribute directly to a specific and credible technical effect that goes beyond just general computing processes.
Specific and credible.
Meaning, you have to show a real, measurable technical improvement. The court noted this could involve enhancing hardware functionality, for example, optimizing data compression by using specific hardware configurations like processors and data storage buffers in a particular way. It's not just about the computer doing its normal job faster, it's about transforming the hardware's capabilities into a specialized apparatus with enhanced efficiency. The improvement needs to be tangible, demonstrable. The Madras High Court echoed this again in July 2024 in yet another Microsoft case. They emphasize that even if a CRI claim exists, if it results in a technical effect that improves the system's functioning and efficacy with an effect on hardware, or provides a technical solution to a technical problem, it can overcome the Section 3K exclusion. And that impact shouldn't be limited to just one application or dataset. It should show broader technical applicability. It's a very consistent message from the courts.
So it's about improving the system's technical performance overall.
Yes. And digging a bit deeper into what counts as a technical effect, the ab initio technology case in July 2024 offered a valuable insight. The court noted that a technical effect should enhance the computational ability of the processor itself, going beyond just the user interface. If an ingenious input system or method allows the processor to produce a more efficient, faster output, that would amount to a technical effect. It's not just about physical hardware changes, but about how innovative software can make the existing hardware perform better, faster, more efficiently. That's key for software innovation.
So the bar is set at a demonstrable technical improvement on the actual system, the way the computer or network functions, not just making things nicer or more convenient for the user on the surface.
Exactly. That's the core principle. And finally, just recently in August 2024, the BlackBerry Limited case clarified the line for algorithm patentability again. The Delhi High Court stated that if an invention relates purely to a set of instructions or policies and algorithm without any substantial change in hardware, it's generally not patentable on its own. However, if that algorithm is implemented through software and results in a technical effect or technical contribution, then the inventive feature lies in that implementation and its technical impact, not merely in the abstract algorithm itself.
So it always comes back to that practical, technical application and effect, transforming the abstract idea into a concrete solution that works in the real world or makes the machine work better.
That's the consistent thread running through all these decisions. Implementation and technical effect are paramount.
General examination procedure for CRIs.
Okay, so we've dissected those specific exclusions in Section 3K, which are super important for CRIs. But it's crucial to remember, isn't it, that CRIs, just like all inventions, also have to meet the general requirements for patentability. It's not enough just to sneak past the 3K exclusions, right?
Absolutely not. That's a critical point. Getting past Section 3K is just one hurdle. Every invention, CRI or otherwise, must stand on those fundamental pillars: novelty, inventive step, industrial applicability, and also sufficiency of disclosure. These core criteria are equally vital and often where applications, even technically sound ones, can stumble.
Right. Let's break those down. Novelty first.
Yes, novelty. This is the absolute baseline. An invention must be new. It cannot have been disclosed anywhere in the world before its filing date or priority date.
Anywhere. Publicly.
Anywhere, publicly. No prior publications, no public use, no previous patents or applications describing the same thing. It's a strict global standard. If it's already out there in the public domain, it's not novel. End of story. Interestingly, the Delhi High Court, in the Erickson versus Lava case in March 2024, actually laid out a very structured approach for determining novelty. They called it the 7 Stampas approach.
7 Stampas, 7 pillars. Sounds thorough. What are they, briefly?
It is thorough. First, you have to truly understand the goals. What exactly is the invention being asserted? Second, identify relevant prior art, find everything published or known before the filing date. Third, analyze the prior art, compare it meticulously, feature by feature, against the claims. Fourth, determine explicit and implicit disclosures. Did the prior art spell it out or strongly suggest it? Fifth, assess material differences. Are the differences significant, considering the whole claim? Sixth, verify novelty of the combination. Even if parts are known, is the specific combination new? And seventh, document everything, provide clear reasoning and evidence. It's designed to make novelty assessment objective and rigorous.
Okay, so that's novelty. Is it new? Then we have inventive step. Is it obvious? How do the examiners or courts really judge obviousness? Because that sounds subjective.
It can seem subjective, but the law tries to make it objective. Inventive step, as we touched on, means the invention must involve a technical advance or economic significance, making it non-obvious to that person skilled in the art. The Supreme Court, way back in the Biswanath Prasad case, stressed that obviousness must be judged strictly and objectively. The core question remains: would a competent craftsman or engineer working in that specific field at that specific time, faced with the same problem, have found the invention obvious based on the existing knowledge and prior art?
So looking back with today's knowledge is cheating, basically.
Exactly. Hindsight is not allowed. You have to put yourself in the shoes of that skilled person at the priority date. The Delhi High Court in Roche v. Cipla also reinforced this approach for India. It's about whether the invention required genuine inventive ingenuity, not just routine workshop modifications based on what was already known. And typically, there's a structured analysis for inventive step 2. Identify the skilled person and their knowledge. Understand the invention's core concept. Identify the differences from the prior art. Figure out the technical problem it solves. Then, judge objectively, were those differences obvious to solve that problem?
Right. Novelty, inventive step. What was the third one? Industrial applicability.
Yes, industrial applicability. This one's usually more straightforward, but still essential. The invention must be capable of being made or used in an industry. Any industry, really. It just means it has to be workable and useful in a practical sense. It needs a concrete benefit derivable from its description. No purely theoretical concepts allowed. Can someone actually build this and use it for a practical purpose? That's the test.
Okay, and the final pillar, sufficiency of disclosure. This sounds particularly important for complex things like software or AI.
It absolutely is, and it's a critical aspect, especially for CRIs. The whole patent system is based on a trade-off, a quid pro quo. The inventor gets a temporary monopoly in exchange for fully disclosing the invention to the public. Section 10 of the Patents Act mandates this. The complete specification must fully and particularly describe the invention, how it operates or is used, and the best method the inventor knows for performing it. The goal is to enable that person skilled in the art to replicate the invention without needing undue experimentation or inventive effort themselves.
So you can't keep the secret sauce hidden.
You can't. For CRIs, this means clearly explaining what the invention is and how to make it work. If it involves hardware, you need drawings. If it's a method, you need sequence steps, flowcharts, details of the implementing mechanisms. How do the components interact? What's the end result? Crucially, the description can't just be about functionality. It needs to describe the implementation. You can't just state the problem you're solving. You have to detail the novel and inventive solution. This is where that Caleb Suresh Motopally case is relevant again. The court found a lack of concrete technical details meant the invention wasn't sufficiently disclosed, even if the underlying AI tech was generally known. You need to provide enough detail so someone else in the field can build it without having to invent it all over again. And related to this, the claims themselves must be clear, succinct, and fairly based on what's actually described in the specification. For CRIs, we look at the substance of the claim, not just clever wording. If, in substance, a claim is really just for a computer program per se or a business method, it won't be allowed no matter how it's phrased. It comes back to the technical essence.
Deconstructing the exclusions examples in action.
Okay, this is great. We have the legal framework, the tests, the general requirements. Now let's bring it all together and look at how these rules apply to real-world examples. Let's focus on each limb of Section 3K, mathematical methods, business methods, algorithms, and computer programs per se, and see what pushes an invention into the excluded category versus what keeps it potentially patentable.
Yes, this is where the practical application really comes into focus. Seeing concrete scenarios helps clarify how these guidelines work day to day. 4.1. Mathematical methods.
Okay, let's start with mathematical methods. We know they're excluded if they're purely abstract. So give us a clear example of something that would likely get rejected simply because it's just math.
A pretty straightforward example of something not patentable would be, let's say, a system for data compatibility index calculation. Imagine the patent claims describe a standard data processing system processor, memory, maybe a display, and specific compatibility analysis module. This module is configured to receive two data sets, apply a specific, maybe novel mathematical formula to calculate a compatibility index between them, and then simply output that index number.
So it just crunches numbers based on a formula?
Exactly. When you look at the substance, the core objective is just applying that formula to get a numerical result. The solution lies purely in abstract mathematical processing. It's just defining an output based on an equation. There's no broader technical objective, no transformation of data beyond the calculation itself. It remains a pure intellectual exercise. So that clearly falls under the Section 3K exclusion as a mathematical method. It doesn't make the machine do anything technically new in the real world.
Right. It's about the application, not just the math itself. If the math just generates a number for a human to look at, that's likely out. But what if that same formula, or a similar one, is part of a bigger technical process? What would make it patentable?
That's the crucial distinction. Let's take a contrasting example that is potentially patentable. A method for controlling a robotic arm. This method might involve receiving input parameters, defining where you want the robot arm's gripper to end up. Then it calculates the necessary joint angles using, say, inverse kinematics equations. That's the math part. But then critically, it generates and transmits specific control signals to the robotic arm's actuators, the motors, to physically move its joints to those calculated angles.
Ah, so the math leads to physical action.
Precisely. Here, the primary objective isn't just the calculation. It's controlling a physical device, the robot arm, to achieve precise positioning in the real world. The inverse kinematics equations are essential, yes, but they're an intermediate step in a larger technical process. The solution combines data input, mathematical computation, and mechanical actuation to achieve a physical outcome. The output, the joint angles, isn't the end product. It drives physical actuators. That demonstrates a clear technical application. Therefore, it does not fall under the mathematical method exclusion. It's leveraging math to make a machine achieve a tangible technical result. 4.2. Business methods.
Okay, moving on to business methods. You stress that this exclusion is absolute in India. No matter how techy the implementation, if it's fundamentally a business strategy, it's out. Can you give us a clear example of something that would be rejected on these grounds?
Absolutely. A classic example that is not patentable in India is a system for dynamic pricing of online advertisements. Let's say the claim describes a network system, a server, a database holding financial data and ad performance history, and a pricing engine module. This module takes in real-time bid data, maybe historical performance data too, applies a set of defined business rules to calculate a dynamic price for an ad slot, and then tells a display module to show the ad at that price.
So it's automating a pricing strategy.
Exactly. The core objective here is purely commercial. Optimizing revenue through a strategic pricing decision. It's a marketing or revenue generation strategy. Even though it's implemented using servers, databases, algorithms, sophisticated tech, the essence of the invention lies in the business logic and the commercial outcome, not in a technical improvement to how the advertising system fundamentally works. It clearly addresses a business problem, how to price ads effectively, and provides a business solution. That falls squarely into the Section 3K exclusion for business methods.
Okay, so if it's fundamentally about how to do business, how to make money, how to manage customers, even with complex tech, it's likely out. But what if it's a technical solution that happens to be used in business context, where the tech itself is solving a technical problem?
Precisely. That's the critical dividing line. An example that is potentially patentable could be a method for enhancing cashless payment transactions at a point of sale, POS terminal.
Echo.
Imagine this method describes configuring a POS terminal to include, say, a near-field communication NFC reader. It receives payment data via the NFC reader when a card or phone is tapped. It then processes that data using a specific secure payment protocol like EMV to authenticate the transaction, encrypts it, transmits it securely for authorization, and completes the transaction.
That sounds like standard contactless payment, though. Where's the invention?
Well, the invention might lie in how it's configured, perhaps a novel way the NFC reader integrates, or a more secure or efficient way the protocol is implemented within that specific POS hardware architecture, leading to faster or more reliable transactions, or better handling of noisy signal environments. The point is, while it operates in a business context, making payments, its core contribution could be a technical improvement to the POS system's operational infrastructure. It's about enhancing the security, speed, or reliability of the transaction process itself through technical means. It addresses technical challenges related to secure data communication, hardware interaction, or signal processing, not just the business act of taking payment. It makes the payment system work better technically. That technical effect means it likely avoids the business method exclusion. 4.3. Algorithms.
Next up, algorithms. We know they're generally excluded if they're just abstract concepts, but if they provide specific enabling details to solve a real-life problem, they might pass muster. What's an example of a pure abstract algorithm claim that would likely fail? A very clear case that is not patentable would be something like a method for cryptographic key generation, claimed at a very high level. Let's see the claim just describes. Step 1, receive a seed value. Step 2, apply a series of permutations using a conceptual permutation engine. Step 3, output a sequence of pseudo-random numbers.
Sounds very theoretical.
It is. When you analyze it, the steps are incredibly abstract. That permutation engine is just a conceptual black box without any specific technical implementation details. How is it built? How does it work physically or logically within a system? And crucially, the claim doesn't show how these generated numbers are actually used to solve a real-world technical problem. It just describes generating numbers. It lacks the technical specifics, the components for implementation. It's just a logical sequence, so it falls under the exclusion as a purely abstract algorithm.
Okay, so it's not enough to have the logic. You need the tangible application, the how it makes a difference in the real world part. Give us an example where an algorithm is part of a patentable claim because it has that tangible application in detail.
Precisely. It needs the technical meat on the bones. So an example that is potentially patentable might be a method for encrypting and transmitting data securely using permutation-based pseudo-random number generation. Now this claim goes into detail. It might specify receiving a cryptographic seed by a dedicated hardware security module, HSM, maybe one integrated into a network interface card, NIC, then generating the pseudo-random numbers, PRNs, by a specific permutation unit within that HSM, then retrieving these PRNs and using them to encrypt data using a standard but specified engine like AES GCM performed by a cryptographic processor within the NIC. Finally, encapsulating the encrypted data into a specific network frame format and transmitting it.
Wow, that's much more specific. Lots of hardware mentions.
Exactly. It goes far beyond the abstract algorithm. It provides concrete technical means, the HSM, the NIC, the specific encryption engine, the processor, and it results in a very specific technical solution. Establishing a secure, verifiable data link with enhanced resistance to certain cryptographic attacks, perhaps. The inventive feature here lies in the implementation, the specific combination of hardware and software components working together in a defined way to achieve a tangible technical effect.
secure transmission. It's not just claiming the idea of permutation-based PRNG, it's claiming a specific technical system that uses it effectively. That makes it potentially patentable. 4.4. Computer program per se.
Okay, this brings us to the fourth and maybe the trickiest exclusion, computer program per se. You've emphasized it's not an absolute ban, the per se is key, and it doesn't even require novel hardware. The focus is squarely on whether the program provides a technical solution to a technical problem through technical means, achieving a technical effect beyond just, normal computer operation or user convenience. What's a common type of software that, while useful, would likely fall foul of the per se exclusion?
You've summarized the nuance perfectly. A very common example that would likely be considered not patentable, because it falls under computer program per se, is something like a system for recipe management. Imagine a system software running on a standard computer or phone that lets you store recipes, search for them, perhaps automatically scale ingredient quantities, and maybe generate shopping lists based on selected recipes.
Sounds useful. I could use that.
It is useful, but from a patent perspective, its core purpose is information management and presentation for the user's personal convenience. The effect is primarily organizing information and making it easier for the user to access and manipulate. This is generally considered a functional effect for the user, not a technical effect on the underlying computer system or the physical world. It's essentially using standard programming techniques, database storage, search functions, calculations, on a general-purpose computer to automate a task a person could do manually, albeit slower. It doesn't enhance the computer's internal operations in a technical way or control physical devices to improve their technical function.
So automating information management for convenience isn't enough on its own.
Generally not. It lacks that core technical character.
So what kind of software does clear this hurdle? When does a software innovation make a computer do something technically better, or perhaps control physical devices in a novel way, making it potentially patentable even without new hardware?
Absolutely. We have to look at the invention as a whole, focusing on its actual technical contribution. A compelling example that is potentially patentable could be an adaptive network optimizer. Imagine a system implemented primarily in software that dynamically adjusts network data transmission parameters, things like transmission power, operating frequency, data packet routing paths in real time. It does this based on continuously monitored network conditions like signal interference levels or current traffic load. It might use standard network interface controllers, NICs, but controls them via a novel adaptive optimization software module.
So it's actively managing the network's technical behavior.
Exactly. This invention addresses a clear technical problem: maintaining consistent and optimal network performance despite fluctuating conditions. It achieves this by directly manipulating the underlying technical characteristics of data transmission. The result is a measurable improvement in the functionality of the network itself, perhaps higher data throughput, reduced latency, enhanced robustness against interference. This clearly demonstrates a specific, tangible technical effect on the operation of a communication network. It goes far beyond mere data processing or user convenience. It improves the technical functioning of the network infrastructure. That makes it potentially patentable, overcoming the per se exclusion.
Advanced technologies and patentability, AI, blockchain, and quantum computing.
Okay, this framework seems pretty robust for traditional software. But what about the really cutting-edge stuff? Our guidelines also specifically address how to handle inventions in artificial intelligence, machine learning, deep learning, blockchain, quantum computing. These fields are changing everything. How do we make sure patents in these areas represent genuine, patentable subject matter, given how abstract they can sometimes seem?
That's a really important question, and yes, it's a unique challenge. These technologies often rely heavily on complex mathematical models, abstract principles, sophisticated algorithms. The core question for patentability, however, remains consistent. Does the claimed invention transform these abstract principles into a real-world, implementable technical solution? Or does it remain just a theoretical construct, an abstract idea? We're always looking for that practical, implementable application that offers a concrete technical solution to a technical problem. And critically, it needs to be disclosed with enough detail for someone skilled in that advanced field to reproduce it without undue experimentation. 5.1. Dealing with AML-DL-related inventions.
Let's start with AI, machine learning, deep learning, AML-DL. These terms are everywhere. How do we treat them in the patent world? Can you patent an AI model itself, or is it always about how it's applied?
It's largely about the application and the technical effect it produces. AMLDL inventions cover a huge range: neural networks like CNNs and RNNs, traditional machine learning, complex training processes. At their core, these computational systems and algorithms can often be seen as abstract mathematical entities. And as we've established, an abstract idea, like a pure mathematical formula or a theoretical AI construct, isn't patentable on its own. It lacks practical application. However, when MLDL innovation takes these abstract principles and transforms them into a real-world, tangible application that actually solves a technical problem, then it absolutely can become patentable subject matter. Now, inventorship in AI is a really hot topic, as you can imagine. We generally categorize AI-related inventions into two types. First, you have AI-generated inventions, those supposedly created autonomously by an AI system with minimal human input.
The AI itself is the inventor.
That's the claim sometimes made. But under current Indian law, these are not patentable. Why? Because an AI cannot be considered a person who can be named as the true and first inventor under Section 6 of the Patents Act. Inventorship legally requires a human being.
Okay, so AI can't own patents yet. What about the other type?
The other type is AI-assisted inventions. This is where humans use AI as a sophisticated tool during the inventive process. These can be patentable, provided they meet all the standard criteria: novelty, inventive step, industrial applicability, and crucially, they demonstrate that technical effect through their tangible inventive application. Here, the AI is viewed as a powerful tool enhancing human ingenuity, not the inventor itself.
That makes sense. The human is still the inventor using AI. What about disclosing these AI inventions? You mentioned that's critical.
Absolutely paramount. Sufficiency of disclosure is a major hurdle for AI patents. Because the field moves so fast and concepts can be theoretical, there's a risk of applicants describing futuristic use cases without providing enough technical detail for them to actually be built now. For a patent to be granted, the disclosure must be precise enough for that person skilled in the art who, in AI, is likely someone with significant expertise to reproduce the invention without needing undue experimentation. That Caleb Suresh Motupalli case really hammered this home. The invention claimed a super-augmented persona using AI, but the court said it failed the enablement test. It just combined existing ideas without giving specific instructions on how to implement the underlying tech, like black box modernization or specific design techniques needed for the claimed result.
So you can't just say use AI to solve problem X. You have to explain how.
Precisely. You need to detail how the AI functions. What's the architecture? How is it trained? What specific data is used, and why is that data suitable? And crucially, how does it interact with hardware or other system components to achieve the specific technical outcome? You can't just state the purpose or list abstract components. You need the implementation details.
Can you give a practical example? Maybe using AI to improve how a computer works internally.
Sure. Let's take improving a computer's internal operations using AI. Imagine an invention that optimizes an operating system's kernel, the core part of the OS, using a neural network for task scheduling. To be patentable, the disclosure needs to describe exactly how that algorithm interacts with the hardware. For instance, how does it predict the most efficient CPU core for a particular task? What input features does it use: thread priority, cache hit rate, power consumption? And you need to demonstrate a measurable improvement, reduced latency, increased throughput. The AI here is directly enhancing the computer's underlying technical performance, making the hardware itself work more efficiently. That's a clear, patentable technical effect.
That's very concrete. What if the invention isn't a totally new AI algorithm, but maybe how you use an existing algorithm, perhaps with a very specific type of training data? Is that patentable?
That's another excellent point and very relevant to AI. Consider data engineering and usage as the invention. Let's say the core inventiveness lies in creating a unique, high-fidelity dataset, perhaps a harmonized, multi-seasonal satellite imagery dataset for crop classification. And this special dataset allows even a standard known algorithm to achieve breakthrough results. In this case, the patent disclosure must detail the entire data pipeline. How was the data collected? How was it cleaned, calibrated across different sensors, stacked temporally? What AI-assisted labeling or validation methods were used to ensure its quality? The inventiveness here isn't the algorithm itself, but the unique, technically superior data that enables a novel and effective technical solution, like much more accurate agricultural monitoring. This shows that the technical contribution can absolutely come from the data engineering and the dataset itself if it leads to a technical effect. 5.2, dealing with quantum computing related inventions.
Okay, moving to perhaps an even more mind-bending area, quantum computing. Principles like superposition, entanglement. It sounds incredibly abstract. How on earth do you apply patent law to something like that?
It is mind-bending. Quantum computing harnesses these bizarre quantum mechanical principles to perform calculations far beyond classical computers. The challenge from a patent perspective is very much about the physical hardware and the practical implementation. Can you actually build a machine that reliably uses these principles? So patentability hinges on transforming those abstract quantum principles into a real-world, tangible application that provides a concrete technical effect or improvement. Again, we're looking for the implementable solution, the engineering, not just the theoretical physics concept of a qubit or entanglement.
So it's about the engineering required to build and control a working quantum computer and what that computer can then do technically.
Precisely. Let's consider a potentially patentable invention, a hybrid quantum classical computing system. This might involve a quantum processing unit, QPU, built using specific transmon qubits fabricated from particular superconducting materials, like niobium titanium alloy on a specific substrate. Then, this QPU is integrated with a classical control unit, CCU, that uses perhaps a machine learning algorithm for real-time feedback, error correction, and calibration of the qubits. The patentability here stems from the specific materials choices, the intricate physical designs, the control architecture that manages the classical quantum interaction, and maybe crucial cooling and shielding systems needed to maintain coherence, preventing loss of quantum information. All these technical details enable enhanced fidelity and minimize errors, thereby improving the actual performance and reliability of the quantum computation. It's about the specific technical means to achieve practical quantum computing, not just the abstract idea. 5.3. Dealing with blockchain-related inventions.
And finally, blockchain. Distributed ledgers, immutability, smart contracts. Powerful concepts, but again, they can feel abstract. What makes a blockchain invention patentable in India? Is it just using blockchain or something more?
Blockchain technology offers that distributed, immutable digital ledger, enabling secure transactions and record keeping. Like quantum computing, while its underlying principles, hashing, consensus mechanisms, can be abstract, practical implementations that leverage these principles to solve real-world technical problems can definitely be patentable. The key, as always, is demonstrating a technical effect and providing sufficient disclosure. Blockchain patent applications need to be comprehensive. They must clearly define the cryptographic techniques used, the specific data structures on the chain, the consensus mechanisms, like proof of work, proof of stake, or others, and any crucial interactions with off-chain systems, hardware, or networks. The focus must be on the technical effect the blockchain implementation achieves. How does it actually make a system work better, more securely, or more efficiently in a technical way?
Can you give us an example where a blockchain application provides that necessary technical effect?
Certainly. A potentially patentable invention could be a computer-implemented method for executing a rental agreement over a blockchain network. Imagine this method involves deploying a specific smart contract onto a particular type of distributed ledger. It verifies cryptocurrency payments received against the contract terms. Based on successful payment, it automatically generates unique, time-limited digital access tokens for the renter. And then here's the technical link to the real world. It uses these tokens to interact with and activate physical assets, perhaps smart locks on a rental property via an Internet of Things, IoT interface.
So the blockchain directly controls a physical thing based on the contract terms.
Exactly. It's potentially patentable because it enables automated, secure, and verifiable enforcement of access rights and payment obligations without needing a central intermediary server. This could reduce fraud and integrates the blockchain directly with physical IoT devices for secure, automated access control. The technical contribution lies in this automated, secure, verifiable enforcement and the integration with physical systems, creating a technical solution for managing access to physical assets. It's not just recording information, it's using the blockchain to achieve a technical outcome in the real world.
That really clarifies how these advanced, often abstract-seeming technologies can be grounded in patent law through specific technical implementations and effects. It's not about the buzzword, it's about the technical problem solved.
Precisely. It always comes back to that tangible technical contribution. Outro.
Well, we've certainly covered a lot of ground today. We went from the fundamental definitions used in computer-related inventions through the intricate legal provisions like Section 3K and explored the quite nuanced interpretations by the Indian courts.
Yeah, especially that technical effect test running through everything.
Exactly. And we looked at how crucial it is for innovations in these cutting-edge areas like AI, blockchain, and quantum computing to demonstrate a real, tangible technical effect or contribution to even be considered for patent protection. It's clearly a dynamic, evolving area of law, trying hard to keep up with the sheer pace of technological change.
And understanding these distinctions, what's just an abstract idea versus a technical solution, what's a business method versus a technical process, it's absolutely vital for inventors, for tech businesses, for anyone involved in innovation today. It's really about ensuring that true technical advancements, the ones that solve real-world problems and genuinely improve underlying systems or processes, get the protection they deserve.
We really hope this conversation is giving you, our listeners, a clear understanding of what it takes for a computer-related invention to successfully navigate the patent landscape here in India, helping turn those brilliant ideas into properly protected assets.
It's a complex area, but hopefully we've shed some light on the key principles.
Thanks for listening.
Stay tuned for more upcoming episodes.
And for reliable and expert intellectual property legal services, remember you can contact TEJICYIP today, or log on to www.tejacewip.com. Our team of experienced attorneys is dedicated to helping individuals and businesses safeguard their valuable intellectual property rights, especially in this fast-moving digital age.